In the case before us, one Judge Rodolfo C. Palatao declaring Section 187 of the Local Government Code is unconstitutional. Insofar, he believes it empowered the Secretary of Justice to not only review tax ordinances but also the power to annul them. He cited that there is a familiar distinction between control and supervision. Control being the power of an officer to alter, modify, set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment to his own, while the second, or supervision, is the power of a superior officer to see to it that lower officers perform their function in accordance with law. His conclusion was that the challenge section gave the Secretary the power of control and not of merely supervision. Also, Secretary Drilon in his resolution declared that the procedural requirements for enacting the new ordinance was not met. Judge Palatao found otherwise, although he declared that all procedural requirements had been observed in the enactment of the Manila Revenue Code and that the City of Manila had not been able to prove such compliance before the Secretary only because he had given them only 5 days to show these evidences, within which to gather and present to him all the evidence. And the evidences consisted of 25 exhibits, later submitted to the trial court. So the judgment is therefore rendered to the reversal of the challenge decision of the RTC and a affirmation that the procedural requirements have indeed been met, because Section 187 authorizes the Secretary of Justice to review only the constitutionality or the legality of the tax ordinance, and if warranted, to revoke it on either or both of these grounds. When he alters or modifies or sets aside a tax ordinance, he is not permitted to substitute his own judgment for the judgment of the local government that enacted the measure. Secretary Drilon did set aside the Manila Revenue Code, but he did not replace it with his own version of what the code should be. He did not pronounce the ordinance unwise or unreasonable as a basis for annulment. He did not say that in his judgment it was a bad law. What he found only was that it was illegal. All he did in reviewing the said measure was determine if the petitioners were performing their functions in accordance with law, that is, with the prescribed procedures for the enactment of a tax ordinance and the grant of powers to the city government under the Local Government Code. As we see it, that was an act not of control but of mere supervision. So in 1997, President Ramos issued AO 372, which required all government departments and agencies, including SUCs, GOCCs, and LGUs, to identify and implement measures in the fiscal year of 1998 that will reduce total expenditures for the year by at least 25% of the authorized regular appropriations for non-personal service items. Section 1 and 2 ordered the withholding of 10% of the IRA to LGUs. Section 4, on December 10, 1998, President Estrada issued AO 43, reducing 5% of the amount of the IRA to be withheld from the LGU. So in the case at hand, there are two issues. One is whether or not the President committed a grave abuse of discretion in ordering all the LGUs to adopt a 25% cost reduction program in violation of the LGU's fiscal autonomy. The second issue is whether Section 4 of the same issuance, which withholds 10% of their internal revenue allotments, are a valid exercise of the President's power of general supervision over the LGUs or the local governments. So as it was ruled, Section 1 of AO 372 does not violate local fiscal autonomy. Local fiscal autonomy does not rule out any manner of national government intervention by way of supervision. In order to ensure that local programs, may it be fiscal or otherwise, are consistent with national goals, significantly, the President, by constitutional fiat, is the head of the economic and planning agency of the government. primarily responsible for formulating and implementing continuing coordinated and integrated social and economic policies, plans, and programs for the entire country. However, under the Constitution, the formulation and the implementation of such policies and programs are subject to consultations and with the appropriate public agencies, various private sectors, and local government units. The President cannot do so unilaterally. So to the second issue, Section 4 of AO 372 cannot be upheld. A basic feature of local fiscal autonomy is the automatic release of the shares of the LGUs in the National Internal Revenue. This is mandated by no less than the Constitution. The Local Government Code specifies further that the release shall be made directly to the LGU concerned within 5 days after every quarter of the year, and shall not be subject to any lion or holdback that may be imposed by the national government for whatever purpose. As a rule, the term shall is a word of command that must be given a compulsory meaning. The provision is therefore imperative.